Does it look like a peaceful protest? These three unelected black-robe tyrannical inferior federal judges get to control the military chain of command and judicially micromanage the exercise of the president's commander-in-chief powers, including the decision about which military forces the president can deploy. If Trump were to invoke the Insurrection Act, and we get a bit closer every day, the Insurrection Act is an alternative justification to 12406, allows Trump to federalize and deploy the National Guard as law enforcement. Basically, he can do whatever he likes with the National Guard under the Insurrection Act, and it's not subject to judicial review at all. That is what's coming if the feckless, unelected black-robe tyrannical inferior district courts are not held in check by SCOTUS here. The great and powerful President Donald J. Trump has once again released the Kraken, his legal warlord, Solicitor General John Sauer, to argue for sanity before the U.S. Supreme Court. And given Sauer's unblemished record of victory in arguing the merits of President Trump before SCOTUS, I have every reason to believe the obstructionist inferior federal judges will be once again pimp-slapped into the gutter where they belong. Those are explosives being thrown on the roof at the federal officers. Does it look like a peaceful protest? I like that the federal officers have a pop-up tent. That's great. Right, this is chaos on the ground. So Trump activates, federalizes the National Guard, asks the governor, Governor Pritzker's permission to do it in Illinois. The governor says no, so Trump does it anyway. Intends to deploy National Guard from California, from Texas to Illinois to address this violence that's occurring outside the Broadview, Illinois ICE facility, where immigration officers are merely attempting to enforce federal immigration law. And he's stopped. He's stopped by a federal judge, Judge April Perry, Biden appointee, who was confirmed by a 50 Senate vote, 50 to 48, I believe, in the third week of November of last year. In other words, she's another one of these Biden judges that was raised to the federal bench after Trump was elected president, but before he was sworn in. He wasn't allowed to do either under her TRO, even though he's the elected Article II executive branch president of the United States, commander-in-chief of all U.S. military forces, with the constitutional duty, obligation to ensure that the laws are faithfully executed. She said no. And how did she arrive at that conclusion? Well, what judges are always supposed to do is apply the law to the facts and come to some legal conclusion. So the first thing Judge April Perry does is apply the most twisted imaginable interpretation of the law to the facts. In fact, she so twists the law that no facts ever existing in American history would justify the president calling out the National Guard, even though roughly half the presidents in our history have, in fact, federalized and deployed the National Guard. 12406 authorizes the president to call out the National Guard to subdue a rebellion or an attempted rebellion, or if necessary, to be able to carry out the federal laws if he's unable to do that with the regular forces. So how did Judge April Perry interpret that? Well, first of all, with one authorization being to put down a rebellion or danger of rebellion, Judge Perry said, well, it only counts of rebellion if the threat is to the entirety of the federal government. The entire federal government is about to be overthrown. It's not enough if it's a slice of federal authority that's being rebelled against. It has to be the entirety of the federal government that's at risk. That is an insane take. and has never been required of any president who's previously deployed the National Guard to enforce federal law, as roughly half the presidents have. George Washington himself activated and deployed the National Guard under his personal command. Once again, he was on his trusty steed riding into combat for America. It was against the U.S.C. rebellion, where the rebels were not trying to overthrow the federal government in its entirety. They were not trying to overthrow the federal government at all. They did not want to have to pay a tax on whiskey. That was sufficient. What about when Eisenhower decided he wanted to enforce a court decision to desegregate public schools in Little Rock, Arkansas? He sent in the National Guard, who chased away those objecting to desegregation at the point of bayonets. American citizens put at the point of bayonets of the National Guard. Were they trying to overthrow the federal government in its entirety? Of course not. They were objecting simply to desegregation of their schools. By the way, how did that all work out? School's doing great now, right? So it's never been required for any of the roughly half the presidents who have deployed the National Guard that it was in the entirety of the federal government that was at risk. But that's Judge April Perry, the genius, the legal genius that is Judge April Perry. That's her standard. Next, she says, well, the other alternative justification for Trump, authority for Trump under 12406 to activate and deploy the National Guard would be if he's unable to enforce the laws with the regular forces. That's the language from the statute. She defines unable as utterly and completely unable. In other words, if Trump tries 1,000,000 times to enforce federal law, and he's able to do it even once out of 1,000,000 efforts, well, then he's not unable. He did it once, so he's able to enforce the federal law. That's the standard she's applying. If you are a parent and you have a child and your obligation is to feed your child, and you're able to do it once out of 1,000,000 times, would you say you're able to feed your child? In fact, I would suggest the standard should be exactly the inverse of what Judge April Perry is applying. The standard should be if the president tries to enforce the law 1,000,000 times and he's unable to even once, that makes him unable to enforce the laws under Statute 12406. But Judge April Perry, being a black-robed, unelected, tyrannical federal judge, would disagree with that and does disagree with that. And then the regular forces. The standard under 12406 is the president's unable to enforce the law with the regular forces. The regular forces in the mind of Judge Perry don't mean ICE and the Federal Protective Services and anybody else, regular federal law enforcement. In her mind, the regular forces means literally the professional, full-time Army, Navy, Air Force, Marines, Coast Guard, Space Force. Under Judge April Perry's reading of 12406, the president is not allowed to deploy the National Guard unless he first tries to address the problem with the full-time professional Army, Navy, Air Force, Marines, Coast Guard, and Space Force. And only if they are unable to address the problem, then the president would be allowed to call out the weekend warriors. Obviously, it's completely insane. Trump appealed this to the Seventh Circuit Court of Appeals, and the Seventh Circuit Court of Appeals basically said, well, we're going to defer to the trial judge about the law, which is not what they're supposed to do. And under her crazy definitions of the law that should be applied, well, the facts don't fit. There is no rebellion against the entirety of the federal government. Trump's not completely unable to enforce the law. Look, he's making some ICE arrests. And he hasn't even tried to deploy the Army, Navy, Air Force, Coast Guard, Marines, Space Force yet. So he fails. Under Judge April Perry's law, Trump has failed to demonstrate that under 12406 he has the authority to call out the federal guard. Madness layered upon madness, layered upon madness. And that brings us to John Sauer's brief now to the Supreme Court of the United States of America. John Sauer is the Solicitor General of the United States, meaning he's the lawyer who argues on behalf of the White House, of the Article II executive branch of government, to the Supreme Court. And as we've seen before, endless times, John Sauer does excellent work. And in fact, for President Trump, the 47th president of the United States, John Sauer has an unblemished, perfect 25-0 record arguing for Trump before the Supreme Court, with, of course, the relentless dissents of Judge Elena, no, I've never been married, never had kids, Kagan, of Judge Sonia, the wise Latina Diabetes Sotomayor, and Justice Ketanji. I'm not a biologist. How would I know what a woman is? And by the way, I don't understand Jackson. And I expect that'll be the outcome this time as well. We'll see as we go through John's arguments. Donald Trump, there it is, against the state of Illinois and the city of Chicago, and the unelected black-robe tyrannical inferior federal judiciary. This case presents what has become a disturbing and recurring pattern. Federal officers are attempting to enforce federal immigration law in an urban area containing significant numbers of illegal aliens. The federal agents' efforts are met with prolonged, coordinated, violent resistance that threatens their lives and safety and systematically interferes with their ability to enforce federal law. That resistance succeeds to an alarming degree in its aim of obstructing federal agents from enforcing federal immigration law. Receiving tepid support from local forces, that would be the local police, they are often left to fend for themselves in the face of violent, hostile mobs. Confronted with intolerable risks of harm to federal agents and coordinated, violent opposition to the enforcement of federal law, the president lawfully determines that he is unable to enforce the laws of the United States with the regular forces. This is the exact language from Statute 12406, and calls up the National Guard to defend federal personnel, property, and functions in the face of the ongoing violence. Now, note, Trump is not calling up the National Guard to enforce immigration law, to act as law enforcement officers. That would be a violation of posse comitatus, which prohibits the use of American military forces for law enforcement purposes. However, as we've talked about before, if Trump were to invoke the Insurrection Act, and we get a bit closer every day, the Insurrection Act is an alternative justification to 12406, allows Trump to federalize and deploy the National Guard as law enforcement. Basically, he can do whatever he likes with the National Guard under the Insurrection Act, and it's not subject to judicial review at all. That is what's coming if the feckless, unelected black-robe tyrannical inferior district courts are not held in check by SCOTUS here. Local political leaders immediately sued in federal district court to prevent the president from deploying federal forces to protect federal agents and enable the agents to enforce federal immigration law. The district court of Judge April Perry then issues an opinion granting injunctive relief against the president's action that downplays or denies the ongoing threat to the lives and safety of federal agents. Again, this is the court. Judge Perry saying, well, it doesn't look that bad to me. To me, she's substituting her own judgment for that of the Article 2 executive branch commander-in-chief about the need for military augmentation. What expertise or competence does a federal judge who's been seated on the bench for mere weeks have to make military decisions? Where in the Constitution does it grant the federal judiciary, the Article 3 judiciary, commander-in-chief authority over the military? She substitutes her own judgment for that of the president, gives little or no weight to the United States' interest in enforcing federal immigration law. Judge April Perry then countermands the exercise of the president's commander-in-chief authority and projects its own authority. I would have put authority in scare quotes here, a rare misstep for the great John Sauer. And the court projects its own authority into the military chain of command. This pattern began in Los Angeles in early June when violent mobs targeted federal personnel and federal buildings to thwart increased enforcement efforts by ICE. After local and state authorities failed to stem the violence, the president called up members of the California National Guard to Los Angeles. A district court in San Francisco twice, remember that old guy? the brother of former Supreme Court Justice Breyer, almost 90 years old, sought to enjoin the Los Angeles deployment, prohibit it. The Ninth Circuit Court of Appeals stayed both of those injunctions, froze them, emphasizing, with respect to the first one, that federal courts owe an exceptionally high degree of deference, at the very least, to the president's judgment in determining whether the facts on the ground warrant calling out the National Guard. Lower court proceedings are ongoing regarding a similar injunction stopping the president from federalizing the Oregon National Guard to address violent opposition to federal immigration officers in Portland. This application concerns yet another injunction, forbidding the president from deploying federalized National Guard members in Illinois in response to months of similar violence targeting federal immigration authorities in the Chicago area. Federal officers in Chicago have been threatened and assaulted, attacked in a harrowing pre-planned ambush involving many assailants, rammed in their government vehicles, shot at with fireworks and other improvised weapons, injured and hospitalized, and threatened in person and online, including by a $10,000 bounty for the murder of a senior federal official. Violent agitators have repeatedly obstructed, that's a federal felony, access to a critical federal immigration facility in the Chicago suburb of Broadview. DHS and other federal law enforcement agencies have been forced to operate under the constant threat of mob violence and to divert resources from enforcement efforts to protect federal agents and property. Local forces, that's the local PD, have failed to respond or unaccountably delayed their response, even when federal agents face life-threatening violence. DHS has also been forced to reallocate resources from enforcing the nation's immigration laws in other regions to protect personnel at federal facilities and the street of Chicago. This all goes to being unable to enforce the laws with the regular forces. On October 4th, the president determined a situation in Chicago had become unsustainably dangerous for federal agents who now risk their lives to carry out basic law enforcement functions. The president exercised the authority vested in him by 10 U.S.C. 12406 to call into active federal service 300 members of the Illinois National Guard. He deployed the federal guardsmen to Illinois to protect federal officers and federal property. They will be joined by an additional 400 from the Texas National Guard. All of these soldiers will serve under federal command, will be deployed solely in a protective capacity, not to engage in civilian law enforcement functions, which under 12406 would be a violation of posse comitatus. 12406 authorizes the president. By the way, that's a congressional authorization, right? 12406 is a statute. So control over the militia is in the hands of Congress, except to the extent they delegate that authority to the president. And 12406 does exactly that. 12406 is Congress, the Article 1 legislative branch, authorizing the president. So he's not acting lawlessly here. He's acting with the authority of Congress to call into active federal service members of any state's National Guard whenever, one, the president is unable with the regular forces to execute the laws of the United States, or two, there is a rebellion or danger of rebellion against the authority of the government of the United States. Both conditions are satisfied here. The president had ample evidence before him that due to violence and the constant threat of violence, the regular federal law enforcement officers, again, Judge Perry says regular forces means the full-time professional Army, Navy, Air Force, Marines, Coast Guard, and Space Force. But of course, any sensible person knows that regular forces in the context of 12406 means the regular federal law enforcement officers in Chicago have been unable to execute fully federal immigration laws and laws against assaulting and obstructing federal officers. The violence targeted at federal personnel and property in Illinois in recent weeks also constitutes a rebellion or a danger of rebellion under the ordinary meaning of those terms, which encompass violent opposition to federal authorities' enforcement of particular federal laws. Unless all of that, the entire U.S. full-time military is unable to subdue Antifa, Trump can't call out the National Guard. He's only allowed to call out the National Guard if those regular forces are unable to subdue Antifa. John Sauer says the rebellion is against the enforcement of particular federal laws. Judge Perry says, no, rebellion only exists if the entirety of the federal government is at risk. By the way, I would point out that under Judge Perry's definition of rebellion, even the Confederate States were not in rebellion against the U.S. because they were not attempting to overthrow the entirety of the federal government. The Confederate States were happy to let the North go about its business. They were not trying to take over the North. They simply were exercising what they believed was their right to voluntarily leave a union they had voluntarily entered in the first place. So by Judge Perry's definition, the Civil War did not involve rebellion because it did not threaten the entirety of the federal government. Madness. The District Court of Judge Perry concluded that the conditions of 12406 were not satisfied here and prohibited the National Guard deployment for demonstrably flawed reasons that will not survive the Supreme Court's scrutiny. As a threshold matter, this Supreme Court long ago held that the authority to decide whether an exigency has arisen justifying the federalization of the militia belongs exclusively to the president, whose judgment is conclusive. Martin v. Mott. The lower court sought to limit Martin to its facts, meaning, well, unless it's the War of 1812 again, Martin doesn't apply. Oh, that's literally what Judge Perry said. Judge Perry said, well, sure, Martin v. Mott said calling out the Guard is exclusively a presidential decision, not subject to review by the federal courts, but that was in the context of the War of 1812, and the War of 1812 doesn't exist anymore. Unbelievable. The lower court, Judge Perry, and the Seventh Circuit Court of Appeals deferred to her, sought to limit Martin to its facts, the War of 1812, but that seminal decision squarely controls here. And even if, the president's judgment were amenable to judicial review, which John Sauers would argue it does not. It is not subject to judicial review at all. But even if it were, such review must be highly deferential, as the Ninth Circuit has concluded in the Newsom, the California National Guard litigation, only weeks ago. Judge Perry's injunction impermissibly substitutes her own defective judgment for the president's on military matters and rests on a reading of Section 12406 that would render the statute a virtual nullity. With respect to 12406 Section 3, Judge Perry concluded the president is not unable to execute federal law so long as any quantum of federal enforcement can still occur. But the president does not need to wait for a total failure of civil power before calling in the National Guard to help keep the peace and ensure that federal law enforcement officers may perform their duties safely. The court similarly limited the term rebellion to organized efforts to overthrow the federal government as a whole, such as the formation of the Confederacy and the firing at Fort Sumter, and dismissed the violence in Chicago as not akin to another civil war. The court acknowledged that violence against federal officers and property had occurred, but sought indefensibly to minimizing it, refusing to credit sworn declarations from federal officials and instead accepting the implausibly rosy assessment of state and local officials who were opposed to the deployment of the National Guard. The Seventh Circuit Court of Appeals granted in part and denied in part the government's emergency request for a stay, a freezing of Judge Perry's order. The Court of Appeals said, well, you're allowed to federalize the National Guard, President Trump, but you're not allowed to deploy the National Guard. Well, that's helpful, isn't it? You can, on paper, say, well, they've been federalized, they're under my authority, but you're not allowed to actually use them against these violent actors in Chicago. That result eviscerates the president's order. Obviously, it's all pointless if you're only permitted to activate the troops but not actually use them. It deprives DHS officers of the protections that the president sought to give them from ongoing violence. It prevents the Guard from ensuring the enforcement of federal law and puts lives and property in danger. It also places the Seventh Circuit Court of Appeals in the untenable position of controlling the military chain of command. In other words, one thing the Seventh Circuit Court of Appeals had said is, hey, we recognize that circumstances could change, and if circumstances change, maybe we would allow the National Guard to be deployed. In other words, they get to make the call, not the commander-in-chief. These 3 unelected black-robe tyrannical inferior federal judges get to control the military chain of command and judicially micromanage the exercise of the president's commander-in-chief powers, including the decision about which military forces the president can deploy. This Supreme Court should freeze Judge April Perry's October 9th injunction in its entirety. The injunction improperly impinges on the president's authority and needlessly endangers federal personnel and property. The balance of harms weighs strongly in favor of interim relief pending appeal and, if necessary, certiorari before the entire Supreme Court so that the National Guard may perform its protective function while any further litigation is ongoing. Given the pressing risk of violence, this Supreme Court should also grant an immediate administrative stay pending consideration of the present application.